On the slopes of Diamond Head, this is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha, I'm Ben Carroll. Welcome to BLAW200, Legal Environment of Business. Well, last time we began our journey through the Uniform Commercial Code, the UCC. So we talked about sales, which is Article 2, and we're going to continue our venture with UCC today, and we'll be talking about negotiable instruments. But first, let's take a look at our review from last time. Where did the UCC come from? And where and when does it apply? Okay, you recall the Uniform Commercial Code is what we call a uniform law, and it comes from the National Conference of Commissioners on Uniform State Laws, so NACUSL is the acronym for that. And this is a body of scholars and representatives from the states that propose uniform laws. And the Uniform Commercial Code is kind of the poster child of uniform laws because it's been adopted in every state. Not entirely. Louisiana did not adopt Article 2 as we talked about, but they did adopt most of Article 3, which we'll be talking about today. So the Uniform Code only applies in those states that have adopted it the same way they would adopt a regular state law, so it has to go through their legislature. And the UCC is a law that has not been changed a lot when it goes through the legislature, so most of the provisions are extremely similar, if not identical, across the country. Okay, who is a merchant under the UCC, and why is this important? Okay, a merchant is a seller of goods, and there are a couple things we look at to determine whether they'll be considered a merchant. So they have to regularly sell goods of this kind. So if they have a retail store and sell a particular thing, obviously that would put them in that category. They can also be holding themselves out or representing that they have special or knowledge and skill in this particular product or this particular type of goods. And we kind of look at that as being a professional, as an expert. We talked about that because we know experts are often held to a higher standard. So in the case of merchants, we have some implied warranties. There's warranties of title, and then there's warranties of merchantability and warranties of fitness for a particular purpose we talked about. So they're held to a higher standard than interactions and contracts between regular citizens. In addition, since they are merchants and experienced, we allow them to deal with each other in their contracting in a more flexible way. So, or you could say a loosey-goosey way. So they're allowed to use open terms and don't have to have the same definiteness of terms that we saw when we were talking about contracts. Okay, what are some differences between common law contracts and contracts between merchants? Again, you had a chart for this, and this is where we saw that statute of frauds applies differently. The requirement of a writing is not so firm under UCC. We saw where we can have open terms rather than the definitive statement of terms that we needed in a contract. So you recall in a contract, we needed to be real clear what the subject matter was, the identity of the parties, the time of performance, and the actual consideration. But when we're dealing with sales, we can have open terms. So we can even have an open term as to the price. So there can be a number of these things that don't have to be stated in our sales contracts. Why? Because the court will fill that in. So they'll fill it in with reasonable. And they know that merchants are dealing with each other all the time. They do these things quickly. So a minor notation will take care of it. Okay, so there are those kinds of differences when we're dealing with merchants under Article 2 UCC of sales and regular contracts that we talked about. Okay, what's the difference between express and implied warranties? And give an example of an implied warranty. So express warranties are warranties that are expressed. In other words, they're warranties that are stated. So if you get a warranty with a new automobile that says the transmission will last X number of years, that's an express warranty that they have given to you. An implied warranty is a warranty that comes from the law. In other words, it doesn't matter whether the seller says that, the law says it for them. And so this was the warranty of merchantability, which means that the goods are suitable for the kind of thing you would normally use them for, and the warranty of fitness for a particular purpose, which means that if you told someone what you needed the product to do and they recommended or gave you a product, it would be held to that standard. So these are implied warranties that we get from a seller. Okay, in the absence of express terms, what will the court consider in interpreting a sales contract? So, again, we know that often merchants are not going to state things quite as clearly as in regular contracts because they're dealing with each other all the time. And because they deal with each other all the time, the court can look behind the express terms, or if there are blanks, in other words, gaps, the court can fill in those gaps with open terms. So if it doesn't say a particular time period, they will apply a reasonable time period, that sort of thing that we discussed. In addition, they will look at how these people have dealt with each other during this contract. So we will look at the course of dealings between the merchants and see how they've been dealing with that. If we don't get anything there, we can also look actually at trade usage. In other words, even if these people don't haven't carried on business, we know that in general, when sellers of this and buyers of this kind are interacting, this is what they do in the business. For example, car dealers, when we say setup charges, we mean X, and that's kind of across the board in the industry. That would be a trade usage. We could fill in the gaps. So if express terms are there, of course, we'll go with those. But if not, we will look at these kind of descending levels of what's going on in the business, what's the norm, what generally happens, and we can use that to help us interpret sales contracts. What are some possible bases of liability against the manufacturer of a product that causes injury? Well, when we first started talking about products liability, we went back and kind of reiterated that with respect to a manufacturer of a product, we can look at the same types of tort liability to start with that we saw when we discussed torts. So certainly they can be negligent. They can be negligent in design. They can be negligent in production. They can be negligent in the materials they used, etc. And we talked about they can have strict liability. So if they're putting something unreasonably dangerous into the stream of commerce, then we may hold them liable as well. So there can be strict liability for those same types of things, defective design, defective production, and defective warnings. So we talked about the necessity of warning people about a product if the danger from the product wasn't open and obvious. In other words, I think we use the example of riding in the back of a pickup. We might not need to warn people about that, or the fact that knives are sharp, etc. But perhaps many of the more complicated products, machinery, and particularly things that are put together like pharmaceuticals, a person wouldn't know what the dangers are. The average reasonable person doesn't know what they might be in danger of. So those things need to be warned. There need to be warnings about those, and so that's another area. And finally, there are the warranties. So in products liability, there is a relationship between the buyer and the seller, and so with respect to warranty, if they have that privity, then there are some other basis of liability as well. And both the negligence and the strict liability isn't limited to the people that were parties to the sales contract. It also extends to other people reasonably foreseeable. Okay, well, we're going to move into another area of the UCC. So we're going to be talking about what we call negotiable instruments. And you can see that we'll be looking at what are requirements, what negotiable means, what the requirements are. We'll be talking about some specific kinds, which include drafts and notes. And one of these will be quite familiar to you. We'll talk about endorsements. You can see that we spell endorsement with an I. You might expect It uses an E, and sometimes that's done, but for this type of endorsement, which is in effect a signature, we use an I. We'll talk about a status called holder in due course, and then, of course, we'll look at the liabilities and defenses involved when we're using negotiable instruments. Okay, so what exactly is a negotiable instrument? Well, this is a writing that we transfer from person to person, and we're using it as a substitute for money or as an instrument of credit, in other words, part of a loan. In the past, and sometimes still, we refer to this as commercial paper. In other words, paper that we're using in commerce. And again, that makes sense when we're talking about using it as money. And this is UCC Article 3. So you recall we looked at, there's 9 articles, and we're going to look at about half of those, and this is the second area we're going to be looking at. Okay, now, negotiable instruments, you say a substitute for cash. Why do we need a substitute for cash? Well, actually, negotiable instruments have some features that we don't have with cash. So they're more secure, and we can regulate them and track them better. So, for example, if you lose money, somebody finds it, finders keepers. So there's nothing that indicates that's your money. It can be freely negotiated or transferred and used by whoever finds it. In addition, the negotiable instrument is going to have some things, some information attached to it so that we can track it and we can see where it's gone, which, of course, for the most part, we can't do with money. So, again, the term negotiable instrument, the negotiable means transferable. Instrument simply means it's a document. And again, commercial paper, same thing. So what are the elements that we need to be negotiable paper? What's necessary for us to be able to negotiate it? Okay, it needs to be a written instrument. We'll talk about these a little bit. It needs to be signed by the maker or drawer. So these are actually the same. This is the person making it. We call it a drawer in some instances. There needs to be an unconditional promise to pay. So this is I will pay. It needs to be a fixed amount. And it needs to be on demand, in other words, when you're presented with the instrument or at a specific time. And it needs to be to a specific person or to order or to bearer. And by bearer, we mean the person holding it, the person with it in their hand. So this last provision is what we actually call the words of negotiability. So the document needs to have words to this effect so that it's clear that we intend that this be usable and transferable between people. And we call those the words of negotiability. So to a specific person, to order, or to bearer. So you'll see to order on your checks and other documents we'll be looking at. Okay, now we need those 6 things to be negotiable, but there's some things that we might think are necessary that turn out not to be. So we can omit the date. In most negotiable instruments, if it doesn't have the date, we will assume that's the date that it was produced. Okay. We can post-date and antedate. In other words, we can put a date in the future or put a date in the past, and that does not affect negotiability. Now, we will be talking about certain people you're dealing with may not allow this according to their rules or what they want, but we're talking about whether or not it's legally negotiable. Okay, there may be no location where the payment is going to be made, and that's going to be assumed at the maker or drawer's place. We can make corrections, interlineations, changes on the note, and that in and of itself won't change whether it's negotiable. And finally, on a check at least, we can say this is non-negotiable, and that doesn't make a bit of difference. So you can put certain notations on your check, and it won't change it at all. But on other negotiable instruments, if you clearly indicate that this is not meant to be negotiable or this is not subject to UCC 3, then in fact you can stop that from being a negotiable instrument. So it will be a non-negotiable instrument. And we'll talk about that. Okay, when we are interpreting the terms, words will prevail over numbers. So very frequently on a negotiable instrument, we will have both the amount written out in words, and we'll also be using numbers. And in that instance, we will be using the words as the more important, having the priority. And the reason I think is fairly obvious, we'll talk about more, but it's much easier to forge or change individual numbers than it is if the number is written out in English. Okay, handwritten terms are going to prevail over typewritten and typed over printed. So this sounds familiar. We talked about this earlier when we were talking about interpreting contracts in general, and that remains the case in negotiable paper. Okay, now when we're talking about a signature, it does need to be a signed writing, but what do we mean by a signature? And this is more open than you would think. So signature is any kind of mark, writing, etc., stamped that, in fact, constitutes a signature. Of course, you've seen this on some bank checks that you get where it has not been touched by the hand of a person. They have embossed signatures, they have printed signatures on the bottom, and this is fine. Okay, the whole purpose of the signature is simply to authenticate the writing and to show that it's bound, the person issuing it, the maker or the drawer, is bound. Okay. Let's just look at a couple of possibilities here. So you see the X, and in fact, people have for centuries and longer have been known to sign with an X. Why would they sign with an X? Well, the obvious example is if they are illiterate. They're not able to sign their name because they can't write. But the other possibility, of course, is they can write, but they're infirm, physically infirm, and can't literally do it because they're sick, broken arm, etc. They may try and sign with another hand, but in essence, this will be a mark. It may look not very similar to what you would expect. And again, in other countries, you can see in the top corner, we have kind of a symbol, and this is known in many Asian countries as a chop, and this is a way that people will sign their contracts, and of course it's done with a stamp. And then finally, this takes us almost back to the seals we talked about earlier. You have the signet ring where people used to seal their documents and show in this fashion, and these all are marks that indicate that I'm affirming the action here, and this, it represents me. I mean to be bound by this. Okay, if we do use signature by mark, and again, this is, for example, when somebody signs with an X, which is the typical mark, X or a cross, then we may need some witnesses. So increasingly, if this is allowed on documents, particularly government documents, then we would want to have a witness say, yes, we in fact saw this person sign. It's sort of like almost similar to the function of notarizing something, is we're having someone else say, yes, we saw this person make this mark, and they indicated that in fact they wanted to agree to this. So you can see this is just a kind of a standard provision. We certify that on this day the attached document was read to the person named on this document, and he or she affixed this mark in the presence of the following two witnesses to signify his or her intention to effectuate the action described on the attached document. So something like that would simply indicate that people who have signed note that the mark is meant to be the signature and have the same effect of the person that wasn't able to sign. Okay, so let's look at the different types of instruments. So we've talked about negotiable instruments, commercial paper, and as I've hinted, one of these might be a check, and that's, of course, we're all familiar with. But there are some different kinds of negotiable instruments, and they fall basically into two categories, some say three. So the first one are drafts. Okay, we consider these to be orders to pay, and they involve three people. So a check is an example of this, and we'll look at these in some detail. The others are notes, and the most familiar note is a promissory note, and this is two parties. One party is saying to another, I will pay you. Here's evidence of that. And then a certificate of deposit is a particular kind of note issued by a bank, and most folks are familiar with that. We won't spend a lot of time with that. Okay, so a draft is sometimes called a bill of exchange, particularly in international practice. They use the term bill of exchange. And it's a three-party instrument, unconditional order to pay. The drawer is the person that makes it, draws it, drafts it. So the drawer is the person that issues it, so to speak. And they issue it to the drawee. And the drawee is a second party who is holding money of the drawers. So again, easiest to think of this as a bank right now. So the drawer tells the bank, the drawee, pay somebody, and that third party is the payee. And in actuality, what happens is the drawer gives the payee the check. And the check is presented to the drawee by the payee, who then receives the money. But there are three parties because one party is holding the money and another party is telling them pay the third party. So this is a draft, and again, the most common is a check, but there are some other flavors as well. Okay. Another type of draft other than the check is the trade acceptance. Okay, and this is used among merchants, and this typically happens when someone is selling goods. So they sell goods to someone and they are to receive money in the future. Okay, so they will give a trade acceptance, and the trade acceptance actually says payable to me, and you sign it saying you will pay me in the future. And this is very common among merchants as a way of verifying that you have, say, accounts receivable, they owe money, and you can then use this trade acceptance as negotiable paper. Obviously, it relies entirely on the trustworthiness of the drawee. Okay, so here's what a trade acceptance looks like. And so you can see that it says pay to the order of ourselves. So we're indicating that we are issuing this, but the payee is going to be us. And we have it accepted by the person owing us some money. So you can see they've already stamped across, and they're going to say at a certain time in a certain place, we will pay this amount. Okay, so this is just kind of a confirmation. This is kind of an instrument that shows that they owe us money because we provided them with goods. And even on the books, we wouldn't necessarily need this because if we had accounts receivable, there would be other indications that we've given them the goods, and we could pursue that under Article 2 sales if we had a problem. But what this does is this gives the business, the seller, this gives them something that represents that money due, and they can actually negotiate this to pay their own debts, because now when they negotiate it, then the buyer will need to pay whoever holds this. And so this allows the seller to obtain credit and to pay their debts, etc., on money that they don't have now but is coming in the future. Okay, so if we compare drafts in general with a very specific kind of draft, which is a check that we're all familiar with, this hopefully will just indicate to you what some of the differences are. So both of them are unconditional orders to pay, but a check is on a bank or a financial institution, savings and loan, etc. So a check can only be drawn on a bank, whereas a draft can be anyone that you're dealing with. Okay, a check is payable on demand. So when it's presented, it can be paid, and we don't think of it as being a future set a date in the future. So even if, and we'll talk about this more, but even if you post-date it, it's possible it can be negotiated right when somebody takes it in. Okay, that's different with a draft. For example, the trade acceptance we showed, where we have a specific date it's going to be paid. And then finally, you can put on the trade acceptance or whatever, you can say that this isn't negotiable. Wouldn't be a trade acceptance, but you can say on your draft that this is not meant to be negotiated. It's simply a notation of the relation. But on a check, it doesn't matter whether you put non-negotiable or not, because the bank will be able to pay. Your notations don't change that. Okay, well, the check is the one we're most familiar with, so you can see that this covers the 6 things that we indicated were necessary to be a negotiable instrument. So you can see it is a written document. It's going to be signed. It's going to have an unconditional promise to pay. It's going to be to a specific person or order of. And there's a time, but this is actually on demand. And there's going to be a fixed amount, which on a check we're going to put in two different places. So let's think about what we mean by an unconditional promise, and that's an important concept. If we say, I will pay you when I get paid, that's not unconditional. So if there are any ifs, ands, or buts in our promise, that's not unconditional. So unconditional means I will pay you, not pay you when, pay you if, that sort of thing. Okay. Now, a promissory note, as we talked about, is two-party negotiable instrument. So we're not asking a third party to pay. We're saying, I will pay. Okay, so we have the maker person that's promising to pay and the payee person who will be paid. So this one's a little simpler. We don't have the third party involved. And here's what a promissory note might look like. You can see it also is quite short, but it has the same elements. So it needs to have the same 6 elements. So it's a written document. It's signed. Okay, it's payable in this instance to a specific person. It's an unconditional promise. I promise to pay. And it gives a certain date, 3 months. Okay. Could also be, as we indicated, on demand whenever you present this. Okay. And a fixed amount. So very simple. Doesn't need to be long to meet the 6 elements. So let's take a look at some other possibilities. Okay, so this is from a brand new case, Hawaii Kingdom, 1887. It says, 6 months after date, I promise to pay to the order of El Ahuna $1,213.35 in silver coin. Now, you might do a little research and see what silver coin in that amount would be worth today, but that's not really our point right now. So does this have all of the elements? Okay, so it's signed. It's a written document. It is to a specific person or order of. It is a promise to pay unconditionally. I promise to pay. It has a date when it's due, and it has a set amount. So this is, in fact, meets the requirements of a promissory note. This is a negotiable instrument. Okay, well, let's take a look at another one. Again, same era. I owe you the sum of $160, which I shall pay on demand to you. So what do we think about that? What kind of questions do we have if we go down our list of 6 requirements? Okay, well, it is in writing. Doesn't look like we have a signature here, so that's something we have to look at. Is this an unconditional promise to pay? Well, it says, I shall pay on demand. Okay. And when are they going to pay? On demand. Set amount of money, $160. So our question here really is, we don't have a signature, and we also wonder who it's to, because it says I and you. So is that going to do the trick? And actually, the court may allow the parties, if this came into dispute, to prove who I and you are. Because remember, if we go back to statute of frauds, they're not going to let us contradict a writing, but they may allow us to explain a writing. And in many instances, the courts have allowed somebody to explain who I and you are, if that's the way that this is written up. The names can be changed all the time. People get married, people change their name, and so the court's not going to say all of those contracts are thrown out if it can be proven who the I and the you are, or if we've used initials or that sort of thing. So this is an area where the court may allow some explanation. And if the parties are in front of the court, they may even allow it without the signature, as long as they establish that the people intended this to be a note. But again, we're not trying to contradict it. We're just kind of adding and explaining and supplementing. Okay, certificate of deposit, again, is a certain kind of note. and it is between you and the bank says, you're giving us money now, and we will be giving the money back to you at a set rate of interest, a set amount of interest. So that's certificate of deposit, fairly common, fairly standard, about all we need to say for that. Okay, what are some non-negotiable instruments? So we've talked about negotiable instruments that have to meet the 6 requirements. There's a lot of instruments that aren't really negotiable. Those might be money orders, letters of credit, etc. So these are money substitutes, but usually they're not going to be allowed to be negotiated the way that we can exchange and transfer the negotiable instruments. And there are a few that people consider to be kind of negotiable, semi or quasi-negotiable, and we call most of those documents of title. And usually these can be transferred, but UCC 3 does not apply. In other words, you can transfer these similar to how you would with an assignment of contract we talked about before, but you're not able to give better rights than you have yourself. And we'll get to that in a minute. That's an interesting feature of negotiable paper, is we can sometimes give someone a better right to payment than we have ourselves. So that sounds a little unusual, but that's one of the features of negotiable instruments. And with these types of instruments, that's not the case. So you are simply giving them what rights you have and what defects in the instrument you're passing along. Okay, so endorsement, you've heard of endorsement. Again, this is going to sound familiar with checks, endorsing a check. And so endorsement really just means the signature. So you endorse with your signature, you're signing it. And there are 4 types of endorsement we're going to look at. Again, you can slice and dice these, particularly the last couple of different ways. But the blank endorsement, special endorsement, restrictive endorsement, and qualified endorsement. So when we look at, we're going to use checks as the example because this is most familiar to you, and you will recognize many of these even though you probably don't know the titles outright. So let's take a look at what we mean when we talk about a blank endorsement. So you can see a blank endorsement is simply signing the back of the check with the name of the person on the front. So this check has been written to paid to the order of John Doe, and John Doe signs the back of it. Okay. Interestingly, you can see it says endorse, and they use an E there. So, well, nobody's going to probably take it out on you if you use an E instead of an I, but properly we use an I here. So John Doe signs the back of this check. What is the effect of that? Well, if the check is made out to John Doe signs the back, who can cash this now? Okay. Well, anybody can now cash this, because what John Doe has done is John Doe has said, pay this. I'm the person to be paid, and I'm saying pay this. So anybody that now has it in their hand, in other words, any bearer, any holder, now can receive money for this. So, hot tip, don't sign the back of your check unless you're attempting to negotiate it right then. So if you're giving it to your bank, fine, or if you're signing it to somebody, fine. But don't sign it in advance, because you have turned this from an instrument only payable to you now to payable whoever has it. So again, you have turned this into a bearer instrument. Bearer meaning whoever has it in their hand. So that's the effect of a blank endorsement. It's really the same as on the front of the checks where it says payable to John Doe. It has the same effect as if you crossed out John Doe and put in some other name. Or if you left it blank endorsement. It's like the front was left blank when it said pay to the order of, or it said payable to cash or something else which is not a specific person. That's the effect of putting on this blank endorsement, just the signature on the back. Okay. A special endorsement specifies who or what to do with the check. So it's telling you to go to a specific person. So here, John Doe has indicated that this check is now payable to Jane Doe. So this would be the equivalent of crossing out John Doe's name and putting in Jane Doe's. So now who can cash this check? John can't anymore. He's given his rights to Jane. So only Jane can cash this check now. Okay, so you can see this is different than blank. This still restricts who it can go to. It still specifies who's to be paid. It's just changed that person. Okay, so that's a special endorsement. Okay, a restrictive endorsement is restricting what can be done with the check. And you can restrict it in various ways. The most typical is what we see here, where it says, for deposit only. So John is indicating the only thing that is authorized, the only thing that I'm authorizing with my signature is the deposit of this check. So again, you frequently will see this when businesses receive a number of checks in the normal course of business, and they'll actually stamp the back. So the stamp on the back will say, for deposit only to specific account at specific bank. So it can be kind of a block of text that says, only place this check can go is our account with this bank or with savings and loan, etc., and even the number, the account number perhaps. So you can be very restrictive as to what's to be done with the check. And again, as you'll see in the other materials, you can restrict the check in different ways, but this is by far the most common restriction, which is saying deposit only. Now, what if you lose this check? Well, somebody attempting to cash that, the bank or the institution is going to look at it and say, this is restricted. This is not to be cashed by somebody. This is only to go into the account. So you can see that protects you much better than losing cash. And that's what we meant when we talked about the value of a negotiable instrument in being able to monitor and restrict how that's used. Okay, now the final one we don't see quite as often, and this is called a qualified endorsement. And this says no recourse. So John Doe is signing this to somebody, and he's saying no recourse. Then what does that mean? Well, we will talk about in a little while, we'll talk about what kind of rights we give to someone when we negotiate and transfer a negotiable instrument. And no recourse is simply, in essence, saying, as is, take it or leave it. You can't come back against me. So if you accept this, you're saying, I'm accepting it without any recourse if there's a problem with it. So when you give this no recourse, you're protecting yourself as much as you can. John Doe is protecting himself from anyone coming back for payment or anything from him. Okay, now we talked about what makes it something negotiable, and we said some things aren't negotiable. So I thought it might be useful to look back when we were talking about transferring. When we looked at contracts in general, we were talking about how we can transfer the rights and obligations under a contract. And you recall that was assignment. So we would assign our right to receive payment or other rights and duties under a contract to another person. So how does that relate to negotiable instrument where we're also transferring rights? Okay. And was hinted earlier, assignment, you're only assigning your own rights, but to some extra things that happen when you're using a negotiable instrument. So, but in assignment, remember we had a writing. We needed a notation that we're assigning. With negotiation, endorsement and delivery, there doesn't need to be a writing specifically saying we're assigning rights. It's intended that these be regularly negotiated and transferred, which is not necessarily the true with a contract. A contract we might not expect would be transferred, but we're expecting, the reason we're using negotiable instruments is we're expecting transfer for the most part. Okay, we need notice of transfer with an assignment. Don't need any notice with negotiation. Again, it's expected. An assignee, person receiving an assignment, is subject to any defects in title, but with respect to a negotiable instrument, we will be talking about a holder in due course, and a holder in due course does not receive title defects. A holder in due course, again, may have rights to receive funds when the person transferring it has lost those for some reason. And an assignment, we're going to be looking at whether there's been consideration, if you remember all the way back to contracts, and we're going to presume consideration in negotiable instruments. Again, make them freer to transfer. That's the point. Okay, so the holder's rights. And so we talk about the person that's holding the instrument. What are their rights? Well, with respect to non-commercial paper, the holder has the same rights, and this would be like an assignee, has the same rights as the person they got this from. So the original contract party will give their rights, no more, no less, to the assignee, okay, to the possessor. But a negotiable instrument can transfer better rights. And again, this is the holder in due course that we'll talk about right now. So who is a holder in due course? Well, you can be an ordinary holder or you can be a holder in due course. And holder in due course is preferred because the holder in due course can receive instruments and not be subject to title defects, whereas an ordinary holder, again, like an assignee, only gets what can be transferred, what the rights are of the person transferring to them. Okay, to be a holder in due course, you need to have given value for the instrument. You need to take the instrument in good faith. In other words, you believe it to be what it says it is, you believe it to be valid, etc. And finally, you're taking it without any knowledge that there's a problem with it, that there's defects or it's overdue or there's some other problem. So this is meant to, in essence, take care of an innocent recipient. So when we talk about a holder in due course, the terminology is not used any place, but we're talking about somebody that innocently receives something, that doesn't know that and is not a party to any problems with it being overdue, defective, some other issue, and you have given value for it. So if that's the case, then you are a holder in due course and you are protected, and we'll look at what that means. Okay, now the defects that you are supposedly not aware of as a holder in due course would be that the instrument's overdue, that it's been dishonored, in other words, it's been presented and not accepted, that it's altered, forged, or incomplete, and that there are claims and disputes about it. So a holder in due course is not aware of these potential problems. Again, they're the innocent party. Okay, so as a holder in due course, you have an automatic right to receive payment unless there are some real defenses. And we'll talk about these down the road. There are some possibilities where the law says a holder in due course is not protected. But in general, the holder in due course is entitled to payment with some narrow exceptions. Okay, so what's the payment process? Well, the holder demands payment. That's called presentment. So we're producing it to the person who is meant to pay it. And if the payment is not received, we call that dishonor. So the person who's meant to pay says, I'm not going to pay. In that case, we may look and see who else in this chain, who else may be responsible for paying. So there may be some people with secondary liability. Okay, so primary liability is the person we first present it to, but there may be other people in this chain that we also have rights, possibly rights against. But there is a certain order, so we would need to present it to the person who stated who's meant to pay it, and then there may be other folks in this process that we might be able to recover from as well. Okay, so when we talk about primary liability, this is the person that must pay unless they have a valid defense. Okay, and again, we'll be looking at defenses in a while. Secondary liability means you only have to pay if the first person, the primary liability, does not pay. So again, there's an order that we have to follow. Okay, we have signature and warranty liability. Okay, so signature liability is someone who has signed the document. Okay, and we have warranty liability, and that means that you are in the chain, you've received payment. So we have both of these types of liability. Okay, now with signature liability, you can see we have primary and secondary. So person making a promissory note or a certificate of deposit has primary liability. So the person who says, I promise to pay, the payee would come back to the maker, and that's the primary liability. Makes sense. Okay, so we saw with a draft, we have an acceptor. So the person that accepts the draft says, I will pay at a certain time and place. So that's primary liability. Now, if those people do not pay, then we would look to those with secondary liability. And secondary liability would be the drawer of a check or draft. So if a person takes a check or a draft to the acceptor or to the drawee and they don't pay, then we go back and look at the person that issued it to us, the drawer, and we might be able to deal with them. Also the endorsers. So anybody who signs becomes secondarily liable. So by endorsing something, you get into that chain where you may be secondarily liable. And here, remember, the one endorsement we talked about was the qualified endorsement. And when we say without recourse, we're saying we're not going to be part of that chain. So if somebody signs something to you without recourse, they mean, well, you can go against the original maker or issuer, but I'm taking myself out of this. So I'm removing myself from secondarily liability. So you don't really want to see without recourse on a negotiable instrument. Okay, now there's some transfer warranties, and these sound similar to kind of the representations we talked about earlier about title and that sort of thing. So what a transferor says that I have good title to this, I have received this properly. As far as I know, all the signatures are genuine and authorized. Okay, I believe it not to be materially altered. Okay, I don't know about any insolvency, bankruptcy proceeding against the maker or acceptor or drawer, and there are no defenses that I'm aware of good, that are effective against me. So when you transfer, you're making these warranties to the person that's receiving this. Okay, if we are transferring by endorsement, we are making these warranties to any subsequent holder that takes it in good faith. Okay, so we're not only making that to the person that receives it, but we're continuing that chain down the line. Subsequent people that receive this can still come back to us as secondarily responsible when we've made this endorsement. If we transfer without an endorsement, then we're only making these representations to the person that actually receives it. Okay, so by endorsement, we're extending our liability to subsequent recipients, whereas without endorsement, if we transfer, we're simply making it to the person we transfer to. So we're kind of limiting who can come back at us. Okay, now presentment warranties. Presentment is when we take the instrument to who's supposed to pay us. Presentment warranties, when we present it, we are saying, I have good title to this, okay, or I'm authorized by the person with title to do this, and I have no knowledge that the maker or drawer's signature is unauthorized, and again, I have not aware that it's been materially altered. I haven't materially altered it. Okay, so when we present it, we are making those warranties as well. Okay, now an accommodation party is someone who signs on and voluntarily enters themselves into the possible chain of liability. So typically we think of this, we don't use the word accommodation a lot in normal parlance, but we might refer to a co-signer. So certainly when someone does not have the creditability or needs some assistance in being on the hook for a loan or whatever, we might have a co-signer or a guarantor. And probably co-signer is the term we're most familiar with. What a co-signer or a guarantor or an accommodation signer is doing is saying, I am also going to be responsible for payment of this. So I'm putting myself on the line to be to pay this if the primary folks do not pay it. Okay, so again, this is a way that somebody that doesn't have adequate credit or reputation or whatever is able to get a loan or to do transactions because someone else that does have that ability or has a better credit history or whatever is also saying, I will be secondarily responsible for this instrument if the primary person does not pay. Okay, now we talked a little bit about the defenses, and the defenses are going to be different if you're a holder in due course or if you're an ordinary holder. And so the kinds of defenses are real and personal. And an ordinary holder, real or personal defenses are effective, whereas with a holder in due course, only the real defenses are going to be effective. So again, this is where it makes a difference if you're the holder in due course, because there's a number of these personal defenses that wouldn't be effective against you. Okay, so what are the personal defenses? They're going to be breach of contract, lack of consideration, prior payment, unauthorized completion, fraud in the inducement, non-delivery. So these all should sound very familiar to us. These are defenses to any kind of contract action. So again, the special holder in due course that's part of negotiable instruments doesn't make any difference here because these are going to be in any contract. We could raise these defenses. And the holder in due course is not going to be subject to these defenses. So this is where we said that the holder in due course can actually be more protected than the original person, because the original person, the ordinary holder, is going to be subject to these claims. And these are the provable kinds of things that the instrument shouldn't be enforced because. And so certainly between the original parties, these would be effective. But as we said, only real defenses, none of these personal defenses, can take away the rights of a holder in due course. So these are not going to be effective against a holder in due course, only the ordinary holder. Okay. How about the real defenses? Okay, the real defenses are forgery, bankruptcy, minority, alteration, duress, mental capacity, illegality, and fraud in the execution. So if these have occurred, it is possible that the holder in due course their rights may be affected as well. So these are absolutely effective. So bankruptcy is going to discharge alteration, illegality. These things will discharge the note even with respect to a holder in due course. Okay, but you can see that the holder in due course, although subject to these real defenses, is not subject to the personal defenses. So it is a very preferred status. Okay, now there is a consumer exception. So because a lot of these consumer contracts occur, the law has indicated that that there needs to be a specific notice attached to these, and that makes these non-negotiable. So this type of consumer credit contract can't be transferred to different people and used in this fashion. So when you have this kind of contract, you know who you're going to be dealing with, and we'll talk a little bit more about these consumer areas when we talk about consumer credit down the road. Okay, so discharge from liability. How do we get discharged? And we're familiar with the term discharge because we looked at this when we talked about contracts in general. So if we are talk about discharge by payment, cancellation, reacquisition, impairment of recourse or collateral, or material alteration. Okay, so by payment, kind of obvious. So if the person primarily liable pays the instrument in full, then all the parties are discharged. Everybody in the whole chain is discharged. Okay. If someone writes across the instrument paid in full, then that's going to discharge all parties as well. So paid in full is a voluntary cancellation. If it's paid by the person secondarily liable, then the person primarily liable remains responsible as well. So the people that paid secondarily can go against the primary person. Okay. Reacquisition then will discharge everyone except holders in due course. So if the original person receives the note back, then they've discharged people in the chain except holders in due course. Okay. Impairment of recourse or collateral, then that particular party may be discharged. So the person whose rights or whose collateral have been discharged would be discharged and others would not. Okay, so that really is kind of a breeze through negotiable paper. Again, there are some more materials that you can see on the website that gives some further explanation of these areas. And we will be talking more, next time we'll be talking more about the banking and the checks. So you can see we've used those as examples quite a bit already because that's a draft that's familiar to you. And we'll be talking more about how the banking system works and the different rights and responsibilities with your bank because that's a contractual relationship. It's subject to UCC 3. There's some things in Uniform Commercial Code Article 4 that apply. And again, that's a familiar relationship and one that's quite involved. So we'll be talking about that next time, along with electronic fund transfers and that sort of thing. So this is Ben Carroll saying aloha. I will see you next time. Happy banking.